El Salvador, and the child was residing with the maternal uncle in the Commonwealth for the past 2 years. This, I apologize.
Take your time.
When the case went before the court, the judge heard the evidence, and she took the matter under advisement. She refused to enter any type of orders on that day, although the child was about to turn 18 in 4 days. The matter was later, the judge issued findings later, about a month later, when she dismissed the petition for guardianship altogether, as well as denying our motion that had been previously filed, our motion for special findings of law. The child did qualify for special findings of immigrant juvenile status, which is a classification under the state statute, which allow a basis for the child to apply for legal permanent resident status. In order to apply for this, the statute requires a three-prong test. One, that the child be declared dependent upon the state. Two, that reunification with one or both parents is not viable due to neglect, abuse, or abandonment, or similar basis under state law. And ultimately, that it's not in the best interest of the child to return to the country of origin. In this, the case at hand, we only have to address number two. We will be asking the court today to remand this matter to the lower court in order to allow for an evidentiary hearing, in order to determine that mother was, in this case, guilty of neglect, and that reunification with her mother, the child's mother, was not viable.
And why, I mean, in the Lopez case coming up, they will argue that all the judge need find is that there's neglect or abandonment by one parent.
Correct.
And they say the father abandoned her, and therefore that's all you need. We don't, did you argue that the abandonment of the father is sufficient by itself to support the finding? And is that your position? Do you agree with your sister coming up that it's enough to find the father abandoned her?
Yes, I do agree with that position, Judge. There are 4 points that I would like to make. Number one, we're stating that in this issue, that the guardianship was wrongfully denied, erroneously denied.
Is that before us? Is that before us? Is that?
That is in my brief, yes.
But is there any consequence to that?
Well, at this point, it will become a moot argument since the child is now 19 years old.
The findings, the failure to furnish the findings you want, I gather, have no bearing on the guardianship determination.
That is correct, because after the matter of Racines versus Escobar, now the judge can enter in under the paternity action as well. The judge retains jurisdiction over this matter. What we are arguing here today, Judge, and the reason why we're asking for the remand is that Judge Ward, when she issued her findings, she failed to, when she issued her findings, she actually answered the wrong question. She goes on to talk about the fact that the child mother could not be found guilty of abandonment because she had the child's best interest in mind when she sent the child to come to live in the United States with her brother, with the mother's brother, which is maternal uncle. And even arguendo, Judge, even if we say that, yes, you know what, maybe she made a valid legal conclusion that would be the case, which we do disagree. However, that is not the question that was being posed. The question that was being posed was, if we look at the reverse, is reunification with one or both parents viable based on neglect, abuse, or abandonment, or a similar basis under the state law? So that was a question that needed to be answered. And she
Is it your position that the judge doesn't have a choice in making these findings? What is it that obligates her to do that?
Well, I think that once we did file a motion, so there are two-step process. In order for us to get into probate or juvenile court, you need to have the basis, whether it's a custody, guardianship, adoption, care and protection proceedings. Once she does have, and they each have different standards. So once you have the, for example, in a guardianship, you are going to be looking at the fitness of the parent. Once that determination is made, and once the child does qualify, and there's in the federal statute is very clear as to there shouldn't be any distinction between a foreign child or a U.S. citizen child. So, but if a motion for special findings of law it's filed with the court, I believe that the judge has the duty, the obligation to review that and see if the child is eligible in order to determine the eligibility.
So what obligates the judge to do that? That's what I'm trying to understand, because it's easy for us if you have a statute or something that requires a judge to make that finding.
Well, I believe that under the even it's the same idea as to a judge in probate and family court has the duty and the obligation to protect that child from neglect, abuse, or abandonment. If in a custody proceedings, the judge will make a best interest determination in order to protect the child from a parent that may not be fit to care for that child. So under that standard, I believe that it applies in the same manner in this case.
But the concern I have is that the neglect provision says that provided that such inability is not due solely to inadequate economic resource. And I don't know why, but the mother basically says, I have no money and no resources, and of course there's no in El Salvador, I gather, there's nothing to help somebody who has no, the government's not helping anybody who is extraordinarily poor, and she is extremely worried about gangs and says, I can't protect you from the gangs. If that happened here, would we say that the mother neglected the child because she could not protect her from gangs or could not support her financially?
Yes, Your Honor. I believe that regardless of where the child is situated, I believe that it would still find mother neglectful due to the fact that she has an obligation as a parent to protect that child. And not only that,
Against
if
the
you
gangs,
look at
what's she supposed to do?
well, she should have contacted the police. If that would have been
El
one
Salvador?
of the, but also, the judge looking at the mother's decision to send the child. So basically, in essence, what she said was, because I have 3 other minor children, because I live in a small home with the grandfather, an uncle, and other 2 siblings, and I'm unable to provide for you. This child grew up without proper clothing, food. So she would go days without food. The only provider in the family was the uncle who worked at a farm, and he sometimes could provide food for the family, and sometimes he couldn't. When the child was 14 years old, she was forced to go to work at a local food store so she could earn some money and help out the family. That, in turn, it started affecting her performance in school. She didn't have time to do homework. She couldn't, sometimes she had to miss a lot of school because she had to go to work and provide for the family. And until she turned 15 years old, when she actually started receiving threats from local gang members who were forcing her to join the gangs. And when she refused, they would threaten her that they would ultimately kill her if she didn't do it. At that point, mother decided that she told her, you can no longer live in this home. So she basically ousted the child and said, okay, I'm going to have you go live with your uncle in the United States. So by that, judge, and the fact that not only maybe she had good intentions in mind.
But you're telling us that it's in the best interest of the child to be with her uncle in Revere. So
it is
the decision of the mother for her to live with her uncle turned out to be in the best interest of the child.
Well, no. I believe that we have to take a step back. So we're looking at the neglect. When we filed this action in the lower court, we did not claim that the mother was guilty of abandonment. Although I do believe that there is an argument that can be made in regards to abandonment, I do believe that in the fact that the mother tells the child, you can no longer, a 15-year-old, you can no longer live in this home, and you're actually I'm gonna place you with smugglers, and you're gonna travel 3 different countries. She crossed Guatemala, Mexico, in order to get into the United States with smugglers, and she traveled for a month in order to get here. I do believe that that can be considered a form of neglect. And abandonment. I think that there's also an argument to be made in regards to some sort of abandonment there. Now, our main focus when we filed this action in the lower court was to, and I believe that the evidence that was presented was supported our argument, which was the affidavits of the mother and the child, which Judge Ward failed to consider at the lower level, was the fact that it was substantial neglect when a parent is unable, and she does, to care for that child for all these years, and she takes no affirmative steps in order to remedy that. I mean, there was no reason for her not to work. There was no reason. She was not ill. There was absolutely no reason for her not to be able to work. She should have worked. She should have provided for this family. She had a duty to do so, and she failed to do that.
Now, if in the next case we're persuaded by your sister that we should interpret one or both to mean either one, as apparently the U.S. Custom and Immigration Service says we should, why should we not simply find in your case that the father abandoned her and that's the basis of the finding?
Judge, correct. I do have 2 points in regards to that. Number one, after we filed this appeal, and before this court decided to sua sponte take on this case, we actually filed a paternity action against father because we do believe that that we should exhaust all the potential avenues in regards to getting this girl the result that she needs in order to be able to stay legal in the United States.
Is it your view that we can't find that the father abandoned her unless we know who the father is?
Well, Judge, that is, in this particular case, we were able to get at least a name, which was helpful in order
Right.
to...
But I mean, the problem, what perplexes me is the mere fact that you have trouble identifying the father and supports the view that he's abandoned her. If he had not abandoned the child, then you would know who he is.
Well, that is correct, Judge, and that is the reason why we filed this action, the paternity action. But furthermore, I do believe that this matter has to be remanded to the lower court because I do believe that Judge Ward had enough evidence in order for her to sua sponte make a determination. After all, this was a guardianship, and I believe that she did have enough evidence, in order to make a sua sponte determination, where she had a birth certificate which did not have a father's name. In the child's declaration and the mother's declaration, it establishes that she has no relationship with this father. And that, in essence, if you look at Judge Ward's findings, she goes on to say that this child does not have a relationship with the father. The father did in fact abandon her.
Could I ask you? I'm thinking about what happens to the parents in these cases who do everything that they can do. This mother sends her child to live with the uncle. And in this case, you come in and you say bad things about her parenting. Is there any consequence for the parents in all of these cases who they're there, but in order to help the child, somebody has to come in and say that they're a bad parent for all of these different reasons? I mean, that's just kind of a dissonance that's troubling.
I do understand the concern, Judge. What I believe is that in most of these cases, the parents have no problem describing the life that the child had while they were living under their care. I don't think that necessarily, the finding of neglect needs to be linked with a malicious act. I believe that the failure to act is also, neglect, and it also satisfies the statute. Again, what I'm trying to say is that it's not a malicious, I mean, the mother did not provide her, food and clothing because she didn't want to. She intentionally failed to do that. It was simply because of the situation, because of the poverty, because she was unable to provide because she didn't have enough money. So I don't think that, again, the statute does talk about the fact that the act does not have to be a malicious act. It does not have to be an act of, an intentional act. Simply the failure to act is enough to satisfy the neglect.
Okay, thank you.
Thank you.